Thank you all for coming this afternoon. My main job is to keep you awake. Okay, I hope that also I'll be able to give you some information about speak English only rules in the workplace and other restrictive language policies. I am going to be talking as a sociolinguist. First, to help me out, how many people here identify as linguist? Okay, do we have folks here who identify as lawyers or attorneys? Okay, good. This kind of helps me know who I'm talking to. Let me start by telling you a little bit about the structure of my talk. I'm going to be giving you a little bit of background on language in the law and the workplace, focusing on speak English only rules there. And I'm just going to use the acronym SEOR for speak English only rules, and these here apply only to the workplace. I'm going to tell you a little bit about my experience with these rules, and the focus there is largely on what it is experts do or what it is I've done, because in my experience, linguistic students in particular want to know, well, okay, so what do you do if you're an expert? What do you end up having to do? I'm going to talk about some of the various challenges that are presented by these speaking English only in the workplace rules, and I'll talk about some of the legal issues, but also the sociolinguistic issues, and then finally I'll offer a quick conclusion. In terms of a general framing of language-related issues in the workplace, I'm going to rely on Piatt, 1993. Bill Piatt was a law professor at the University of New Mexico, and he said anytime you're thinking about language in the workplace, the issues are going to fall into one of four categories. And the only two that really matter for us with speak English only rules are those of communication among employees, employees talking to one another, or employees dealing with customers, clients, and patients. That's where these rules are focused. Now a little bit of background information on these rules themselves. Speak English only rules are interestingly permitted by Title VII of the Civil Rights Act of 1964 as amended. They fall under a subcategory of language-related issues that are linked to national origin discrimination. So that's what we think of. And we'll come back to why would they be there rather than some other place if we're thinking about civil rights. And indeed, this is why the EEOC itself and its guidelines as I'll explain a little bit later, the EEOC issues guidelines from time to time about its current understanding of these rules and indeed the Civil Rights Act generally. And what the EEOC wrote in 2016, and indeed the same text had appeared in earlier guidelines, because linguistic characteristics are closely associated with national origin, it is important to carefully scrutinize employment decisions that are based on language to ensure that they do not violate Title VII. And employment decisions here are anything having to do with employment, not just who gets hired or who gets fired, but also everything that happens in the workplace. Okay? In terms, just as a little bit of background on these, rules, the EEOC gets between 150 and 200 complaints a year related to speak English only rules. The EEOC investigates at least some of these, and occasionally it will decide to intervene in the court case. Based on what I understand, its decision to intervene results from at least two main forces: limited resources that they themselves have. They can't intervene in every case. And then second, they're especially interested in cases that would lead the court potentially to draw what attorneys call a bright line. This is legal, this is not legal. Because as you'll see, that's not the world that we live in right now. Because there aren't any Supreme Court rulings that involve speak English only rules. And we've got some major precedential rulings, but they're generally 1980, 1993, there's one from 2000. What you get instead is a patchwork of district court rulings, some of which we could just say are frankly contradictory. So different courts are reading the rules in different ways, and that's never been adjudicated simply because the Supreme Court has never even drawn the first bright line. These cases, as most cases, are settled out of court. I would contend that the main reason they're settled out of court is I imagine the employers want to avoid the bad publicity. And if you want to talk about what that might mean, that could come up perhaps during the question and answer period. As I said, from time to time, the EEOC does issue guidelines on interpretation, and the most recent ones were issued in 2002 and then in 2016. My point is here, it's maybe like 12, 14 years between guidelines, and lots of things change in American society and in the social sciences in 12 to 14 years. In terms of what the EEOC guidelines do say about Speak English Only rules, first, the guidelines presuppose that such rules may be needed, and it details requirements for what these rules need to look like. It presumes that any rule that states at all times you must use English, for example, is going to be burdensome, and it will constitute a violation of Title VII, and thus it will be subject to scrutiny. And it also recognizes the possibility of business necessity, and this is something that we'll return to. An observation I'd make here is, for me, there's something quite ironic about these rules. In the cases I've looked at and the cases I've read about, and there's quite a bit of case law on these rules, what you will find, certainly in the cases that I know about directly, but also in these others, you can imagine that what you've got there is a hostile work environment, aside from the Speak English Only rules. Those of you who are familiar with employment law at all know that the bar for demonstrating a hostile workplace is very, very high. But what happens is, if you happen to have a Speak English Only rule and people are not informed about it, it is not consistently enforced, or there are other things going on related to that rule, you may be able to get your foot in the courtroom door. So ironically, the existence of these rules, which many people would see as discriminatory. In fact, many Americans are shocked to find out that your employer can tell you that you must speak a particular language in the workplace. But the point is, their existence sometimes helps language minority groups out, but the very fact that they are there, particularly if there are problems with them. What I'd like to do now is just give you some idea of the topics covered in the 2002 and 2016 guidelines, and this will give you some idea of how certain things have changed and how things have remained the same. In both, there's a section on accent discrimination, there's a section on fluency requirements, there's a discussion of English fluency. In 2002, there was a discussion of foreign language fluency. Now the discussion is fluency in languages other than English. For me, this reframing is quite significant. Third, there was a discussion of English-only rules in 2002. Now the discussion is of English-only rules and other restrictive language policies. The word restrictive had been used in the text earlier. Now it's in the heading. We are now calling these restrictive language policies in the land of the free and the home of the brave, where freedom matters. Okay, so the acknowledgement is something is being restricted. We may need to pay attention to it. The 2016 guidelines are much more highly informed and sophisticated with respect to simply how they talk about bi- and multilingualism. They're more explicit in terms of their instructions to employers about the rules, when you can use them, when you can't use them, how they need to be formulated, and they also set a much higher bar for their legal use, particularly in terms of if you're going to make a claim of business necessity. So there's been a real shift here in terms of how the EEOC talks about these rules, and if you go back and look at earlier guidelines, you can see this clear development. A little bit about my experience with the rules. I've been an expert witness in three such cases. One involved a Catholic university in 2000, a family-owned business in 2003, and a large healthcare organization in 2011. In two of these three cases, the EEOC was a named plaintiff, and that's a big deal in terms of the power they bring to the case, but also HR, human resources departments, pay attention to what the EEOC is doing, because that's where they figure out what they need to be doing. So when the EEOC is part of a case, it comes to be quite important. As I said earlier, the cases were settled out of court. When the EEOC settles out of court, there's always a news conference talking about what happened, talking about the settlement, and also talking about what has been agreed to. So this is, again, part of educating the public about these sorts of issues. One other thing I did, in 2013 I was on sabbatical, and one of the attorneys I'd worked with got in touch with me and said, the EEOC is having an open comment period about these rules. Because you have been in several cases and you are a linguist, you might have some interesting information to share with the EEOC, and I sent them a 25 single-space document. 25-page single-space document. And I'm happy to say things I talked about got mentioned in the rules. In the revision, I would also say the EEOC was getting information from lots of places, so I don't take any credit for that. But I'm happy to see that at least I was thinking about some issues that probably other people are thinking about. In terms of the kinds of research I've done and undertaken, as you would expect, I've analyzed depositions, I've interviewed plaintiffs to get report data on their patterns of language use. I've supervised the interviewing of plaintiffs where the attorneys wanted evidence of code switching. I've administered assessments of individuals' abilities to speak English. I've analyzed various versions of Speak English Only rules to see if they were consistent. I've analyzed various documents introduced as exhibits. The most interesting one that we perhaps can talk about during the question and answer period is something was referred to as a letter of apology when in fact it was not. And the defense clearly from reading the depositions, it's clear the defense was going to try to construct the plaintiffs as being uncooperative because they wouldn't accept this apology that had been offered to them. And in deposition after deposition, and I read 20-odd depositions for this case, no one would accept the apology. I finally saw the letter. I knew why they wouldn't accept it. It was not an apology. I could demonstrate that because, hey, I know a little bit about discourse analysis. Okay. I've also provided basic information about current understandings of bi and multilingualism, sort of, bilingualism 101 for attorneys. And then I've suggested possible lines of argumentation. You often work with the attorneys and give them ideas about how to frame something or give them information they may not be aware of. In the healthcare case, this involved Filipino nurses. They were not, and I will come back to this case, this situation a little bit, they were not aware at all there was something called Philippine English. And further, that it had dictionaries. Courts love dictionaries. Okay, and so if we can establish that this thing exists and that it's been written about, this may be useful, and we can talk a little bit about why that was the case. And then, as experts generally do, I've written these very long expert reports based on the research, and then I was deposed. As I said, I want to talk a little bit about the challenges that Speak English Only rules present, and it seems to me these fall into three categories. The first is what we might call the court's ideology of language, especially with regard to bi and multilingualism. The second is there's some unsettled legal issues that linguists need to be aware of if they're going to talk about these cases. And then there's some what I'll call unsettled sociolinguistic issues. The court hasn't, and these rulings don't seem to appreciate certain issues in the way that sociolinguists might appreciate them. In terms of thinking about the language ideologies of the court, as a reflection of the dominant society, I'm going to give you some quotations from an article by Janet Ainsworth, who was mentioned this morning. Ainsworth, to my mind, is the legal scholar who most thinks like a sociolinguist. I don't know where she got that knowledge, but boy, she's just with us in terms of understanding how language functions in society, and particularly how it functions in the legal process. In terms of thinking about Speak English Only rules, these are the things that Ainsworth has noted with respect to the court's perspective. And it's very useful for linguists to understand this. The court assumes that languages are transparent media of referential communication, such that everything that can be easily and unproblematically said in one language can also be faithfully rendered in another. This gets back to the question this morning about, will a translation of the Miranda rights do? And most of us will say, necessary but not sufficient. Okay? Her second observation is that by definition, a bilingual person is adept enough in both languages to have satisfactory communicative competence in either, regardless of the context of language use or register of language performance. And if we look at the precedential cases, they happen to involve bilinguals who had fairly high degrees of ability in both languages. Indeed, in some cases, they were native speakers of Spanish and English, for example. though there are many other cases where that doesn't hold, but this is still how the court thinks about what bilinguals are. The third thing they assume is that the specific language used by a bilingual individual is always a conscious, deliberate choice, which makes the choice to speak in a language other than English an intentional violation of the English-only policy. And then finally, rules banning the use of languages other than English cannot be considered the equivalent of direct discrimination based on ethnicity, because language use, being a voluntary choice, is not an immutable characteristic linked to racial and ethnic identity. And this is indeed the kind of reasoning that you see in a number of the precedential cases having to do with these rules. As I said, I want to now say a little bit about some of the unsettled legal issues with respect to language and Title VII. Something I didn't mention here, and I realize I should, someone used the phrase primary language this morning, Bill did. That's a term that attorneys, that the legal profession simply uses. No, I can't find a definition of it. I can't find out who the first people to use it were, but they simply assume everyone's got a primary language, one, okay? And so it's not exactly necessarily a native language, it's not dominant language, so there's not a clear mapping of the terms that linguists tend to use onto this legal category of primary language. The second thing is the mutability or immutability of a person's primary language. Mutability or immutability, can it be changed or not? Certain things like national origin can't be changed. If I were born in China, I was born in China. That can't be changed. Okay, religion, that's mutable. Increasingly in this society, many people are willing to acknowledge that biological sex is mutable. Okay, so things are changing there. Well, what about primary language? The next notion is the extent to which the ability to use English should enjoin one to use that language. Next, whether and when language should be considered a national origin characteristic, and that's really a sticky issue. That anthropology early in the 20th century tried to pull those things apart. Next, the nature and limits of business necessity. What should that mean? When could it be used? And finally, the extent to which the EEOC guidelines about language and national origin deserve deference from the courts. Some district courts defer to them, others don't. In terms of the unsettled sociolinguistic issues, I'll cite 4 that are actually quite related. The application of such rules to individuals who cannot in fact comply. What if someone doesn't speak English at all or doesn't speak it very well? The problematic nature of the notion of language choice. We sociolinguists use that term all the time, even though we're quick to admit it's not always about choice. The conflict between cultural norms and a speak English only rule. And then finally, the accommodation or treatment of expanding and outer circle varieties of English in the workplace. And I'm going to try to get to these and give you some examples from transcripts of depositions that I have read. So this whole notion of choice, we didn't even know if we were speaking in our own language, or if we don't know if we are speaking English or speaking Tagalog or Ilocano. And Ilocano was misspelled in the deposition that I saw. So this is the notion of just choice. Second is the notion of choice and cultural norms. Well, as I said, if you're working with a Filipino, it's out of respect, to talk to them in your own language, and it comes out naturally without even knowing if you're already talking in your own language. And this gets us to the notion of varieties of English other than inner circle varieties. In terms of dealing with the speakers of Philippine English, those are clearly outer circle variety speakers. But here's what happened in the workplace. Because most of the management, like the director of nursing, like the supervisors, our coworkers, even if we're only talking the English with somebody else, because of our accent, they just say, shh, speak English. Even they did not hear if we are speaking in English. Shh, speak English, English policy. They're making fun of your accent. We're talking in English, but they think you're still speaking in your language. She said, you guys have to speak in English only. And I answered back, we're speaking in English, can't you understand? I just have a strong accent. And she just turned around. I was in the nursing station in special care, and I was answering the phone. And then I called, Manang, this is your phone call. And then someone behind me said, I didn't know she was there. She told me, if you speak again Tagalog, I'm going to write you up, including your charge nurse. Then the attorney from the other side said, you were answering the phone, and the call was for who? The answer, I said, Manang. Maybe she's thinking I'm talking Tagalog, because Manang is a respect for our elders, and you can find Manang in the dictionary of Philippine English. It's based on the Spanish word hermana, okay? And it is a term of respect for an older female. So some quick conclusions. Clearly, there's the challenge of balancing business needs and employee rights, and that's the title of the Piatt book. Second, I think we can see the evolution of the EEOC's understanding of sociolinguistic issues relevant to speak English only rules, and I see this as great. We got a long ways to go, but boy, we've moved somewhere. And then finally, I do think that we as experts have a lot to offer the legal profession. I have learned a great deal from working with them, and I like to think they've learned some things from working with me. Before I stop, I got to make two quick disclaimers. Everything written in these slides is discoverable in any future cases that I might be asked to serve in. So that has something to do with what is written and what is not. And second, I speak as someone with training in language, culture, and society, not as an attorney. Please do not construe anything I have said as legal advice. Thank you.